So there's some fire folks in the room, right? Raise your hands.
Oh, yeah.
Okay, I always do that before I say something, make sure I'm not outnumbered by the law enforcement. So I kind of got a weird family. My wife's a battalion chief for the City of Surprise. Yes, I'm a captain, so that means I report to her. She outranks me. My younger son's a third-year Phoenix firefighter. And our daughter just completed her first year as an LA County Fire Department Ocean lifeguard. Our other son is in the financial industry, and he took a different career path. So those of you that are on the fire side may have seen a social media thing called Fire Department Chronicles. Raise your hands if you read that. It's a pretty hilarious social media website, pokes a lot of fun at some of the stuff that we do. And see in real life, just as I'm sure the law enforcement side has some Twitter pages and so forth on some of the crazy stuff they encounter. So by chance, my younger son's in Florida, and he sees this fire truck pulling to the lot, and he sees this guy that he recognized from social media. He's like, holy cow, that's the guy that has hundreds of thousands of followers. So my son goes up, and this is the non-fire one, says, hey, I'd like to meet you. I'm Kevin. I've been following your page for quite a while. He says, but I'm the disappointment in the family. He says, my dad's a fire cap, my mom's a battalion chief, my sister's an LA County Fire Department lifeguard, and my brother's a Phoenix firefighter. And the guy goes, well, nice to meet you. You'd only be a disappointment if you're in law enforcement. So I love my brothers in blue. They know it. There's some sitting in the back. I serve on a lot of boards and commissions with them, work in the streets with them on a daily basis, but we always have a lot of fun together. So nothing but love for them. But of course, we always poke a lot of fun at each other. So that's all I'll do, Stan.
It's good times.
Don't mute my mic again.
We talked about this. Local board legal counsel. If you're dealing with a disability issue, it's suggested, strongly suggested, that you retain legal counsel and use a court reporter. There's, in all honesty, there may be about 10 attorneys statewide that are probably proficient in the law and been experienced in this special niche. So seek those out. And as far as a court reporter, you can have a court reporter there and they can do all their work. And it's a fee to have them there. It gets expensive when you have to produce that record. When you say, okay, I want this all typed out in longhand and that sort of stuff, that's when it gets a little expensive. You don't have to do that for everyone. You can just have the court reporter do their records and save it. And then you can even, if you're going to have part of the record typed up, they'll go back and do portions of it for you that you would need for your thing.
I speak to a number of boards across the state, both on the police and fire side, and I'm sure many of you that have worked with attorneys and all different aspects of your life, they all have different opinions. And believe it or not, there are some attorneys out there, or actually a number of attorneys, that have incorrect perception of the PSPRS law and some of the things that relates to that are in statute. So in the city of Phoenix, every so often we'll do an RFP for professional services. It's just a customary thing, even though we're an independent board of the city of Phoenix. We're not going to do this, but if we decided as a board we wanted to go buy a building down the street and run the police and fire pension office out of there, legally we could. We got that in a opinion from 2 different attorneys, but we're not going to. But however, we have the legal right to select our attorney. So, but what we do to keep in line with the city's procurement process is about every 5 years or so, we'll do an RFP for professional services for an attorney. So in our RFP for an attorney, we specify specific things that they need to be knowledgeable and skilled in pertaining to PSPRS. We'd be happy to send out our RFP to anybody that wants to see it. But you would think that all the attorneys that are out there, we would be flooded with responses to our RFP. And there really hasn't been, because we are very specific in there. If you just put out an RFP that says, hey, we need an attorney for local board matters, there's legal professionals that do a lot of work on different boards. Water districts, lighting districts, flood control districts, irrigation districts, we could go on and on and on, but local fire and police pension board is a very specific area. So those of you that serve on these local fire and police pension boards I ought to really probably question, you know, or do we have the most qualified legal professional to represent us in the event of a lawsuit, and also for your members that come before you for application of various types of benefits. So RFP, our RFP in Phoenix is very specific. We'd be happy to get that to you if those that are interested, but that's kind of how we do it.
Well, it could be the best money you spend, and you know, you have probably heard that joke. You know why divorce is so expensive? Because it's worth it. Okay. And I've never been divorced. That's what my friends tell me. So there's a disability exception. You can't qualify for an accidental, catastrophic, or ordinary disability if your injury is suffered in a felonious act or enterprise. If you're a criminal, if you're doing things wrong, and you hurt yourself, corruption or something like that, it's not going to. You can't go back and use that. If you have service in the armed forces and you're getting disability pension from there, or it's listed as a disability with them, or if you have a physical and medical condition or injury that existed or occurred before the member's date of membership in the system, this is why you do, and I saw Phil was talking about it, this is why you do your, your pre-existing report and that sort of stuff. I assume you all do a pre-existing report. So the pre-existing report is they do their medical, it comes back and it says, hey Stan, you had a knee injury in high school, playing football, yada, yada, yada. It's just there. It doesn't mean that you can't get a disability pension for that knee injury. But if it just slowly deteriorates and there's no traumatic incident at work, you know, or something like that, then it may exclude you from getting it. So usually if you send these letters out, it usually causes 2 or 3 people to go, wait, what the hell? What are you talking about? You say, no, we're just saying, hey, you had one.
As a local board member, that's one of the first things I look for. I look for the pre-existing report of injury that should be at the front of the record when you get it. So I look at that just to see if there's anything that could possibly be involved, because that's also going to be what if the case is ultimately referred to an independent medical examiner, that's one of the things that they're going to look at. And we may even put in the language when we're sending somebody out to an IME to see if the disability and the permanency or any part of it was contributed to by a pre-existing condition. Because if we don't do that, everything is reviewed at the PSPRS level by legal staff, and it could be kicked back for review by the local board. So, but I always look for that firsthand. Every now and then we may not have one, but that's very rare. But that's just one thing that you should be doing. When they're hired into the system, there should be the record. Just as well, there should also be some kind of documentation that allows the new member to refute that medical information by submitting additional records or medical information.
When can they apply for an application of disability? After the disabling incident. Remember, we want them to be stationary. Okay? So it's not, here we go, you know, I didn't sprain my ankle yesterday and I'm retiring tomorrow. We want you to go through that rehabilitation process and be stationary, or within 1 year after the date the member ceases to be an employee. Theoretically, a person can retire and come back 6 or 7 months later, and he can try to make the case that he had an injury that totally prevented him from doing a reasonable range of duties. Timely application is a prerequisite for it. So
the question always comes up, you have somebody that's in drop. Are they allowed to apply for an accidental disability retirement? And when this first all started, when the drop, the 5th year of the drop, which is the maximum time length you could participate, 60 months, the question came up, and we referred it to out to our inside and outside counsel, can somebody apply for an accidental disability while they're in drop or after their drop period ended? And the question came down to, what were they doing on their last day of work? Well, if they were driving a fire truck or riding on a fire truck, and I tell our guys on the fire side, if it's anything that could go code 3, lights and siren, then you were in your position on your last day. But if they had extended period, they spent their last year and a half in the drop and they were on alternate duty with ongoing continuing medical care and treatment, then they were disabled. So just because they're in drop or just because their drop had terminated does not mean that you can just say, well, we're not going to accept this case or hear it.
Right, and so the person can actually put in 2 or 3 months before the end of his drop, or 5 or 6 months, and it takes too long, and then his drop expires, so that his pension would start And then after you heard his case, it's just simply going back and recoding it from a normal retirement to an accidental. And that's, the minutes get sent over to PSPRS, and it gets recoded in their computer, and then the tax benefit comes out for it.
So where it comes in, if some folks are sitting around in the bar and somebody says to the other one, hey, did you apply for that accidental disability retirement? And they've been gone like 6 or 7 months. When they left, the question is, like I said, we'll go back and look at what was their attendance, what position were they in the last few months, if they were riding a truck to the very end. Now, granted, firefighters and even police officers, they don't want to stop working because there's a whole host of other challenges that go along with the industrial system, that goes along with reduction in benefits and so forth. There's really not a whole lot of financial incentive. So folks will continue working, okay? There are folks riding trucks that really probably shouldn't be there. They're broken, but they want to go and reach for that brass ring and leave. But if they were at work on their last day, in any type of operations position, they don't meet that requirement. So that's why we're very careful. We go back and look at, what were they doing? Was there ongoing medical care and treatment? Are they stable and stationary? When did that take place? If they were stable and stationary 2 years before they left, well, that's probably one we're going to look at probably denying. But it also depends on what they were doing on their last week of work. But there's a misconception out there that just because somebody's in drop, just because somebody exited drop, just because somebody left the job because of their retirement date, they're excluded for any, permanent benefit or any kind of disability benefit. And that's not the case. You have to look at it, very closely, review the entire medical record.
Right. So, elected board members, police and fire, remember, one of your responsibilities is to educate the members. So I would hope that they get referred to you and you have that general conversation with them about what their benefits are and about how this process is going to go. And so one of the things you have to explain to them is, remember, we want you to be stationary. So before you apply, you tell the member, before you apply, there needs to be some notation in your doctor's notes that you're stationary. Stationary meaning you're as good as you're going to get. You're not going to get much better. In fact, you might deteriorate. So telling them that what the doctor needs to make in the notes for the board to have a simpler thing is okay. You can't tell them which doctor to go to. I can tell them which doctor to go to have his shoulder replaced or his hip replaced, but I'm not going to tell them to go for the IME to that doctor. And there's we have tons of doctors we know that put Humpty Dumpty and firefighters back together and that sort of stuff. But yeah, you're not going to get to pick
Humpty Dumpty was a cop.
Humpty Dumpty was a cop. He liked donuts. Okay.
One of the things, though, the other thing that I ask for, that I tell our members, is that you have to have some permanent restrictions. If he just says, my doctor says, well, I can't come back to work. Well, what exactly did he say? Do you have permanent restrictions? He says, well, I just can't work as a firefighter. Well, if they have some kind of restrictions that the doctor says are permanent, anti-stable and stationary, those are the things, then I said, you could consider applying for an accidental disability retirement. But if you don't have either of those things in there, we're going to table your application. Anybody can pick up an application and file and start the process. We'll table that application if it doesn't meet those initial criteria. And I'll tell you another story kind of along those lines, maybe a little different, but somebody that is completely broken up comes and says, and that they're broken, they can't physically return to duty, they just think the board can grant an accidental disability retirement. No, in state law, you have to send them to an Arizona licensed physician for the independent medical exam. So even if you have knowledge that, they're never going to be able to return back to work, they're serious injuries, you cannot grant that disability benefit unless they go to an IME. In that particular case, what I would just do is, if they feel they can't, then they have the opportunity to apply. That's the local board's determination then on, how they proceed, and if they refer them to an independent medical exam, then that's one aspect of it.
Yeah, so you don't usually hear, I don't want to be a firefighter anymore, but it's quite often, I don't want to be a cop anymore. So
yes.
But that doesn't mean you're disabled. That just means you don't want to do this job. And just because you don't want to do this job, it may be cold to say, just because you don't want to do this job doesn't mean that it's your municipality's and my pension system's responsibility to make you healthy, wealthy, and wise and walk the beaches of San Diego for the rest of your life. So, I mean, that takes there's going to be a lot of discussion, a lot of interview, and there's going to be a lot of doctor's visits there on that one. Because remember, it's not what your doctor says, it's not what you say, it's what our doctor says. Okay? Sometimes you have to deliver bad news.
Usually the board, there's 4 basic questions that got to be asked, and then the board can add additional questions, such as the one regarding review of the medical record to see if there's any pre-existing condition that contributed to this, even though that's one of the 4 questions. Did this injury or condition exist prior to membership in the system? We've thrown that question in as like, if there's some question that maybe this is an old injury from a previous employer or from a previous time in their life before they became a firefighter or police officer.
Well, the board can direct them to injuries, specific injuries, and/or more information. And the board can also authorize that doctor that if it's beyond their scope or they need to send them to maybe a neurological thing or something, you can make your motion so that you give that doctor the authority to make those moves. The job of the board is to do the pre-screen on that. We're going to pre-screen for what? We're going to pre-screen that it occurred in the line of duty. Is it a well-documented injury that shows he cannot do a total and permanent disability that prevents him from doing a reasonable range of duties? If you don't answer all 3 of those questions, you're not under any burden to send him out, okay? If it's yes, but we're going to talk about 4 different things here. If it's yes, then you send him out. Okay?
So the case that we were sued in on the Phoenix Fire Pension Board revolved around us not sending the member to an IME because I told you, we look at their work history. We said, gee, you worked on your last day. And the response was, I was told I had to be at work on my last day. Well, who released you for duty? I don't know. Somebody just told me I needed to be at work on my last day. So did the person clearly have a physical injury that caused future problems? Absolutely. Did it happen in the course of his duty? Absolutely. But state law was like, his last day of employment, he was on a vehicle that could respond on a Code 3 basis. So we didn't send him. That's why we were sued. And it went all the way up to the Court of Appeals.
Go ahead.
I had a situation, well, no, I'm not gonna, that the local board approved a disability retirement because at that time, the treating doctor said that this person had permanent restrictions, that this person could not be continue to do the functions of his job. When we sent him to an IME, the actual IME said complete opposite. The IME said that this person is able to perform all aspects of the job. So I had our local board IME said this person can continue to be a police officer. This police officer's treating doctor said, no, this person cannot be a police officer anymore. I mean, we did what we needed to do when it comes to the board, and we submitted everything to PSPRS. My question is, what would you do in this kind of situation?
What did the employee say? Did the employee say, okay, I'm going back to work?
Oh, no. The employee continued to stand in the fact that I can't do this job.
Okay, what did he say was wrong with the one that said that he could do the job?
He disagreed because his doctor said that he can't do the job.
I'm chasing my tail. It's what my doctor says, not his.
Correct.
A solution would have been is you could have sent him out for a second IME and specifically asked that IME to address specific issues. And then when you get 2, then that, once again, in law enforcement, we call that the walks of life discussion. Maybe you're not cut out to do this. It doesn't happen in the fire service very often, but
what's the purpose of sending to a second IME when your IME, the board's IME, said in the lady's particular case that he was quite capable of going back?
Well,
you go off of the IME, not off of the personal doctor.
If you and your attorney are happy with that, vote no. Tell him to go back to work, okay? But if he points out that there's some discrepancy in there and this doctor missed that or that, and after review of all the information that you get, you think, okay, maybe we do need to have a second look at this, then you can send him out. I agree with you. If my first doctor said no, then and you vote no, whose burden is it to prove that I'm disabled? So as this slide's about to tell you, once the guy says, I've hired legal counsel, you're nothing more than a cheerleader. You're not sharing any more information with him because all of a sudden you're going to conflict yourself out. But there have been times where people haven't been happy, or they pointed out where the doctor didn't get this or get that, and we've sent people out to second IMEs.
We've had a rash of second and third IMEs recently because the IME reports have come back not complete or in disagreement with the condition, where it was very clear in the record. The fire department physician said in extensive documentation that no, this person cannot go back. They have permanent restrictions. And then somebody that's never seen them before says, oh, this person can go back to full duty. You just kind of shrug your shoulders and go, who exactly are we looking at here? So with knowledge of local board members of the particular situation, as well as the medical record, that's why our system allows us to make some other choices. You can let the existing IME stand, or you can refer them to a second or third IME, and then the board has the ability to decide between that medical evidence from the IMEs. And we've had to do that before because the big marketplace for IMEs is in the worker comp world, probably right there with the auto insurance world. So, adjusters are constantly getting independent medical exams for automobile accident cases, as just as well as worker compensation cases. And I've seen such a huge disparity in these IMEs that I can tell when we send somebody out for a pension board IME what that author or physician spends most of his time doing when the report comes back. I can look at it and say, well, this provider does a lot of worker compensation IMEs. So I told you about the one that came back. Well, yeah, he can do some of the duties, but he can't climb anything higher than a 3-foot tall step ladder. Okay. Yeah, hey, I can't reach the third floor balcony of this burning apartment fire. That's as tall as I can go to save somebody. But that just doesn't exist. That partial duties do not exist. You can do what we have done in the past, and it's allowable. In the next board meeting, you can contact that physician, have them appear before your board, which is probably pretty highly unlikely, but you may be able to get them on a conference call phone and ask them more specific questions regarding your, the condition in the IME. We've done that before. They wouldn't appear, but they said, hey, give us a call and we'll help you. And one case, that made it even worse. We shouldn't have ever done that. We ended up going out for another IME. But that is one way to, resolve it. The other way to do it is send them a letter asking them to clarify and be more specific and get an addendum to that IME report sent to you for the board to consider.
All right, first disability is an ordinary disability. It's a physical or a mental condition. It's a physical condition that determines, let's go to that. I broke it down here. For those of you who need to look this up, it's under definitions. Don't go looking deep into the code. Look under definitions. It's in alphabetical order. Ordinary disability is a physical condition, prevents the totally and permanently reasonable range of duties, or a mental condition that prevents them totally and permanently from engaging in substantial gainful activity. Means they got to be pretty messed up, okay? Or, why are ordinary disabilities so rare? I think on Phoenix, we've only had 2 on the police side. I don't know how many.
We've had 2 or 3, and usually it's due to some adventure type things that firefighters and police officers engage in: high-speed motorcycle riding, off-road quad riding. Some of those things are where we've had to give out ordinary disability benefits. Folks that didn't want to leave the workplace, but they were so physically incapacitated that they could not return to work, and it happened in an off-duty setting.
So here's what the payout on it is, and if they want it, send them back out because But you'll find most people, it's just not. It's not very valuable. I mean, it's valuable if you have nothing else. But so the cop that buys a bass boat that does 70 miles an hour and they decide this is going to be neat to water ski behind it, and they go 50 and they fall and it totally destroys his shoulder and he's gone, depending on how many years on he's got, maybe he'll take this, maybe he won't. But we find that when you take an ordinary disability, generally it doesn't even pay for your health insurance.
So my question is dealing with reviewing disabilities that we've granted. Everybody sitting on a board has had one come through, left them scratching their head. Not everybody voted, wasn't a unanimous vote. If we have somebody who was granted a disability and suddenly they're engaged in substantial activity, i.e. a job that paid more than the job they left, are there windows, opportunities, do's and don'ts on reviewing those?
So before we answer your question, which we will, we're going to ask another question. What is the most expensive disability? Catastrophic? No, I'm not asking that. You would think so because it's a higher percentage. Oh, all right, Neil. Oh, okay. That's one. The most expensive disability is the unfunded one. So that would be what?
Less than 20 years.
Less than 20 years. You have somebody that's been in the system for 10 years. They haven't paid all the way for their full 20 years. The employer hasn't paid all the way for 20 years or 25 years. That's the most expensive disability because you've created an unfunded liability for your employer. Now, the question is reviewing those. So this is where I wanted to get to. So if you grant, and I tell everybody this, who has less than 20 years that says, hey, I'm thinking about applying for an accidental disability retirement. I say, hey, if you're applying and you got 10 years, the local board by law has the right to review your disability every year, okay? Well, in most cases, when it comes before us, we have some personal knowledge or information about the individual that we don't even, bring them back. But however, we have the right to bring somebody back for an independent medical exam to see if they're still disabled, meet the requirements to continue receiving the accidental disability retirement. Now, for somebody that, say, has over 20 years in the system, and we're still going to talk about Tier 1 and Tier 2 because Tier 3 hasn't gotten there, or Tier 2 and 3 hasn't gotten there yet, that's not an unfunded disability retirement. All that really is a tax benefit granted to them by IRS on the taxability of their disability. It's not unfunded. But anything less is an unfunded disability, so less than 20 years, you can bring them back to see if they still meet those requirements. And you look at their medical record, you also send them out. You don't have to send them out to an IME. It's kind of expensive. They're like $3,000 if you get a good deal some places, but they're at least that and more. So if you want to do that, then if they don't meet the requirements, I believe one of the requirements is you have to offer them a position.
So
in
here,
your agency.
so the phrase comes to mind that some people brighten a room when they enter, and some people brighten a room when they leave. So do you want him back?
Does the air get sucked out, or does it come in?
You're going to spend $3,000 or $4,000 to send him back. You're going to have to go to HR, and he probably wasn't your shining star anyway. And now you got to find a spot for him, and you're going to do what? And so, yeah, you can do it, and it has been done. And there's actually been some pensions that have been pulled from people for if they don't go to that doctor's thing and stuff. But you only track them up to 20 years. And it's a reduced. They're not getting rich on you. And sometimes your work environment's a lot better without them, frankly. So.
If you were thinking about offering them a fire job instead of police.
And you know what? Hey, driving a Barcalanger is a lot easier than a Tahoe. That's for damn sure. So.
Harley, I wish I could see one of those.
Temporary disability, they're also rare. The unique thing about a temporary disability is you don't get any money out of this thing, and you have to terminate employment, and it's only paid for 12 months. We have done one that I know of in the last 30 years with the city of Phoenix. I don't know if you've done any at fire or not. They're just not.
What's that, a
temporary?
No, we haven't. And I think the only place you would see that, and because we haven't granted, would be maybe in some kind of jurisdiction that's so small that they don't have any benefits to which to provide. I'm talking about a sick leave or vacation or sick leave or some kind of leave accrual program. That's the only time I could see that. We've never granted one in my jurisdiction. Plus, like I said, I've been in this for like 24, 25 years now on a small local board.
We're having a battle over here, Cheesehead and Viking. So
Oh, that's
Actually,
all over.
we're going through one right now. He just finished his temporary, refiled for permanent. So we have to do the IME to see if he's followed his original
Right.
doctor's plan.
Yeah.
So
So yeah, that's usually after a
Yeah,
period
so
of time, you have to do something.
They can do that, and you have to redo your due diligence and that sort of stuff, so yeah.
Now, you have some latitudes on some things here, but I'll just tell you from a personal perspective. Let's just say you have somebody who has a disabling injury and they can't come back to work. But however, maybe there's a doctor that says, yeah, if he gets the surgery, he might be able to come back to work. So the questions then become, do you require them to undergo that surgery in order to possibly come back to work? I'm going to give you my perspective. So you're going to tell somebody as a local board, you need to subject yourself to possible seizure, coma, death, or long-time MRSA, or leave the workplace. I mean, that's a pretty easy decision for me to make, because we had an applicant a few years ago that had a knee replacement. He was told he had to have a second knee replacement. He didn't want to leave the workplace. So while he was in the hospital's first knee replacement, he blew a pulmonary embolus, coded in the hospital, was dead for like 4 minutes, and they resuscitated him. He came back and said, I'm not getting my second knee done. I just got a bad feeling about it. You know what? I agreed with him. So, you think about that. Is that something that you really want to do?
Yeah, no, if we replace body parts with metal parts, then, yeah, I mean, look, there's a Tempe officer, I think, that's got a prosthetic leg or two. There's other people that do it. I agree. But the same thing is, if we've cut half of your leg off or a total knee replacement and you don't want to do it, let's get the medical record together and go, because it's an accidental disability. All right, so he's going to go at his high 3. He doesn't avail himself of drop or anything else like that. So let's cover accidental disability. Physical or medical condition totally and permanently incurred in the line of duty. A member's employment must be terminated by reason of the accidental disability. And I say this in jest, but everybody knows it's true, not because he's about to get fired. So,
speaking of those employees that are about to get fired, what's our obligation to that employee that gets the medical retirement and subsequently has their certification revoked, but we're going to call them back for that reevaluation? Because you mentioned we have to offer them a position. Is it any position in the city or a position in the system?
no, it has to be in the system.
So this employee can no longer serve as a police officer because he's revoked his certification. He's done, but we know that medical needs to be reviewed. So
Why would you review it? Because you have to offer him a job. Why spend $3,000 to send him out if you know he's not employable? That's like in Phoenix, you've got a serious closed head trauma and the doctor says, this guy will never be the same. And you spend all that time there. Why would you send him back out? Okay. Or the one guy that I made a mistake on is I said, well, I didn't believe this guy. So I said, let's send him out on his knee. And the doctor comes back and says, hey, his total knee replacement from 8 months ago has been a complete success. It's like, oh, Jesus, I probably should have talked to him before I sent him out. But you know your people. That's the value of your local board members here. You know your people. You know the stories. And if somebody really wants to come back after that and they've made themselves whole and you got room for them, then maybe you take a flying leap on it. But I think you're going to find out that when you go down that line and you see that this shoulder's gone, it's been replaced, or pick one, or they have cement and steel. They got a cage in his lower back. And, they might be able to ride in that special fire truck, but they can't ride in that Tahoe because they have to jump out of that and do that combat shotgun roll and have to do all that neat, sexy shit. Sure. All right. So, look, you have the right to do it, but you have to be careful that you don't do it just because you can. Because it's not a fiduciary responsibility. Don't be wasting money from your municipality that you don't have to waste. So, I'll go stand over here off my soapbox.
Okay, we're running short on time here. We're getting the.
Yeah, I know. We are getting a lot of great questions. So.
Okay, let's finish this accident. We got a couple more to do too.
Yeah.
Here.
Calculations, the same as your normal retirement. It's just that you're working for a tax exempt benefit on that.
Yeah,
So
we still had another question about the previous one in regards to them submitting, and even before we would even think about sending an IME, it just seems coincidental that they filed this accidental disability the same day that they were going to be called in to be fired and terminated. would
Yeah, that
we
gets-
legally be able to say,
Yeah?
turn him down?
Well, not turn it down.
Or-
But, you know, so there's a part of the state law that says you can't get that misconduct investigation until the discipline's been metered out. Where's my plea guys in here? Isn't there a part on that that says you really don't have access to that until some of that investigation and disciplinary process is done? Okay? But, so you kind of got your choice. And we had one in Phoenix where there were all sorts of allegations and stuff. It's like, well, we need this information to find out if this, are you being fired because of your misconduct, or are you being fired because of an injury you had 6 years ago? We need that. And he says, well, you can't have that. And we said, okay, I make a motion that we table this gentleman's application until the appropriate records are available for this board to review and make that decision. Okay?
The tax
That
exempt.
doesn't happen in the fire department. Rarely.
I'm looking at them like, where does this happen? All of our folks like to come to work. They don't. We have to kick them out. The tax exempt portion of the pension, that applies to your first 50% of your pension, and that's an IRS provision. I get questions about this all the time. This isn't a City of Phoenix thing. It's not a PSPRS thing. It's an IRS provision.
Catastrophic. A physical, not a psychological condition that prevents an employee from totally and permanently engaging in any gainful employment, okay, incurred in the line of duty. So these should be rare. You shouldn't give this out to your, this isn't, you know, like a hotel chain, friends and family deal. This should be rare. I can think of the couple in Phoenix that we've had, physical condition, not mental. We had a young officer who did a traffic stop. He had like 3 years on, and he got hit by a drunk. You know, as he's reaching in, he got hit by a drunk down here in Ahwatukee. And by the time they got done rehabbing as best he could, he was a high-performing quadriplegic in a wheelchair. Is that catastrophic? There's no gainful employment there, right? That's catastrophic. Okay. We had another guy that had similar. He had a serious ankle injury. They went in and completely rebuilt the thing, and he ended up getting MRSA and lost half of his lower right leg to the issue. And it was like the doctor said, no, this, you know, he was on pain meds and stuff like this. So they gave him a catastrophic, but they go back 60 months later and they say, okay, your catastrophic is going from 90 back down. Your board secretaries, they'll put it on there and you go back and reevaluate it. You take a look at it. You can, you know, come up with it, but it's going to get reduced or you're going to leave it the same. The guy in the wheelchair, he keeps his because he earned it.
We've done
His
two
family earned it.
on the fire pension board in Phoenix. We've done two, and fortunately, both folks were, very seriously injured, and didn't even survive much longer than 5 or 6 years post award. So, what else we got?
What else we got here? We already went through this, building that legal record for review. You know, if you're not getting what you need, where do you go? Ask the chair. The chair should have a relationship with the employer and say, hey, we think that there's records here, either employment records or something that we'd like to review. Tell us what they are, and let's have a discussion. Your chair can have that discussion. Ask your attorney. I was telling somebody in the hall that when we had a very contentious case, and I knew we were going to go into it, I called my attorney up the day before, went out to coffee with him, and I says, well, here's my impression. Here's what I think I can do. I'm not violating the open meeting law because I'm doing what? Talking to my attorney. And then I asked him, if I make a motion to deny this, what's not in the record you need to defend us? What more do you need there? Ask the attorney. You're paying them. You'll find that they are very accommodating. If they're not, then they're not your attorney very much longer. Talk to another elected board member. Hey, what do you know about this guy, Brian? Oh, no, I was out there that night. He is messed up. This is bad. Okay? Talk to the HR director. What's their sick leave record and that sort of stuff. Ask the applicant that you want more information. I want more records. I found a note in some of your medical information that said you had an accident before you got hired because you got hit by a major petroleum oil company truck, and come to find out there was an out-of-court settlement on it, but it's sealed. Oh, can we get those records? No, it's sealed. You go back into court, you go back into your board, and you say, hey, I make a motion that we ask them to ask the court to unseal these records. Of course, they're going to say no. And the next motion is, I make a motion until we table this. We table this until we get the information that we need. You schedule for 3 or 4 months down the road, give some time to consult their attorney and figure out what they're going to do, or if there's other information that will help us. And if not, you post it, deny it, let them get an attorney. And nobody likes to get sued, but if you set the record right, you'll survive it. The burden of proof is on the applicant. If you're not getting what you need, make a decision on where you can go find it.
Is there a statutory limitation on the time that you can table an act?
Well, we've had some table for a long time because of some issues, but you'd be working with your attorney, and your board secretary should be sending a letter. Say, Stan, your motion for this and this has been tabled for 3 months now. We're asking for these medical records. Do you have any additional information or not? And if they answer you, fine. If they don't answer you, you've got a record of that effort of communication. And sooner or later, the board needs to get off the pot and make a decision. Because if you deny it, then what happens? By denying it, what occurs? Invokes the time frame for an appeal on that person's part. So then they have to make a decision, because if they don't appeal it in 60 days, it's final, right? Okay? So, I know we're kind of telling you to be, I know firefighters are kind of.
Firefighters, we're over and done with. Stan's getting the hook now. So, last slide, Stan.
That's it. Should be it.
So,
there it is. Go back one. That's how you get a hold of Phil Coleman. He knows everything. He knows everything that he spotted that I had his phone number wrong on this thing. So you call Phil Coleman's first, you call Stan the Man Hoover second, and Brian actually works for a living, so you call him third.
That's right.
You can call any one of us. So
we keep law enforcement honest.
So
thank you all. We had some good questions.